So Dina, are you going to start or?
Well, I'm going to share the screen and I'll do the first slide or two. And then I thought David was going to do his bit and then you on Capo.
Right, I think though that we're already started, so we should probably say hello and we'll be starting in just a minute.
We're live.
We're live.
Yeah, but we don't have any participants yet.
Yes,
we
mine's
do.
showing 61.
I show 55.
Why don't
Hi,
I-
everyone. We're live.
Sorry.
And we'll get started in just a moment. We're just sorting out a few little technical things. So thank you for your patience.
Esta presentación está ahora en vivo. Vamos a comenzar en unos cuantos minutos. Estamos preparando, así es que nos dan un par de minutos. Gracias.
I'm not seeing the language choice. Sonia, should that be up right now?
It hasn't been enabled yet.
Oh, okay. Alex, if you can hear us, could you enable it? The language choice, please. Ah, there it goes. So for panelists, when you see the interpretation sign, if you just click on that and choose English. Okay.
Yeah.
And I am going to share the screen.
What?
Thank you again, everyone, for your patience. We are live from Sherman Oaks.
Oops,
Waiting for him.
hold on. Am I not sharing? There we go.
I believe David may be held up on a call, Dina, so perhaps we should get started
Okay.
and
that's
then we can just change the order when he's able to join us.
Okay. Well, hello, everybody. Thank you for joining us this evening for our spring update. There's been a lot of things going on. We're going to try to give you as much as we can up to the minute information. Hang on one second. I have to, I'm not very technologically inclined here. Okay, so as always, we have our caveat that this is what we know as of this minute, and to always please check our website regularly for up-to-date information. And there's our web address on that slide. So, and this is just kind of a repeat of what I've done in the past, or we've done in the past, and it's just that school districts' legal obligations under the Individuals with Disabilities Act has not changed. The districts are still required to provide qualified students that are eligible for special education with a free appropriate public education. And the most recent Supreme Court case dealing with special education is the Andrew F. case, which came down in 2017 and raised the bar somewhat that the student's education needs to be appropriate in light of that student's eligibility, in light of that student's abilities, and also so that they can have and make progress appropriate in light of their abilities, I think is what the court said. Okay, and then just the basics that what FAPE is for each student is going to be based on his or her needs. Students are initially assessed to determine eligibility. they develop an IEP. I'm assuming that everybody that's on this webinar knows about IEPs. If there's anybody that doesn't, please ask a question in the chat box. IEPs are reviewed annually to make a determination that the student's making progress. We know for sure that the federal law hasn't changed. There was a state law at the beginning of the pandemic that allowed districts they gave districts an exemption from conducting assessments of students, and that ended on July 1st of 2020. Many of the districts failed to conduct assessments at that time and didn't even start redoing assessments until the schools started opening, most of them at the beginning of this current school year. So what I do know is that there's a lot of backlog of assessments out there and children who have not been assessed for quite a period of time. Now I have some slides that David, we're going to come back to David's, hold on a second. And Valerie, I'm going to have you speak a little bit about CAPO.
Okay. Hi, everybody. Just a couple things. If you have questions, if you could post them either in chat or in question and answer. We're going to actually save a fair amount of time at the end of this presentation to answer those questions. And it's our hope that we'll be able to get to all of them. We think in the course of the presentation that there may be questions which arise, and we do want to answer those and give as much information as we can. So please do put them either in the Q&A or in the chat, and we will get to them at the end. I'm going to talk for a few minutes about a case that came out. It was our New Year's Day gift. It came out at the very end of December of 2021. And I think it's safe to say it was at best a surprise and at worst a terrible disappointment to many of us in terms of what happened in the case. The case is this case that is known as Capistrano Unified School District versus SW and CW on behalf of their minor child, BW. The case numbers on the two cases are what are listed on our slide you have. As I think was posted, the slides and the webinar will be available on our website. The case has been certified for publication and will appear in the Federal Reporter. What that means is that is a case that is supposed to be given greater meaning. It has greater importance because it's going to be what's called a published decision. We do not yet have the Federal Reporter citation for it, but it means that school districts are of the view that they have achieved some really wonderful victory. For reasons that you will hear me say as we move through this, I'm not so sure it's as wonderful as they think, but it is certainly a case that we need to be aware of. The case arose, as do all bad cases sometimes do. You know, the theory of lawyering is that bad facts make bad law. And in some ways, that's what we've got here. There was a bitter dispute, and it clearly from the decisions was quite bitter, between the Capistrano School District and the family. The parents disagreed with what the district was providing for their child, withdrew their child from the district, placed the child in a private school, gave notice that they were placing the child for the first and second grade, and then filed for due process. Capistrano, as might be expected, denied reimbursement. They proposed holding an IEP meeting, but unfortunately, for reasons that are not made clear in the decision, the parents did not respond to that. The allegation is that the parents didn't actually receive the notice, but that finding of fact seems to have gone up against them. They did agree ultimately to the assessment, but then the parents refused to produce the child for assessment. At the administrative hearing, which is, as you know, the first step in these proceedings, the administrative law judge who heard the matter held that the district had denied the student a FAPE, and that they failed to file for due process on the disputed IEP, and failed to have an IEP in place for the second year. It ended up with one of those kinds of decisions we see from the California Office of Administrative Hearings, in which it was something of a split decision. And as a result of it being a split decision, everybody appealed. You could go to, is there a next slide? Yeah. What happened on appeal is the district court ordered Capistrano to reimburse the parents for the second grade year, which the judge had not done, the ALJ had not done. Capistrano then appealed that portion of the decision. And what happens in this case is very significant for everybody who's listening to this webinar and for everybody who works in this area of law. What the Ninth Circuit did was it said that the parents had not requested an IEP meeting for their child for the second grade year. And the fact that the district already knew the family disagreed was not significant if you are not in a public school system, if your child is not attending the public school, if you're outside the public school in a private school, and you want to have an IEP meeting, this court held you must request the IEP. In practical fact, that means the following. If you have been unhappy with the school your child is attending, and you have moved your child to another setting, then you need to, a private setting, if you want to retain any rights under the federal law called the Individuals with Disability Education Act, you must send a written notice to the district asking for an IEP meeting to be held for the upcoming school year. You cannot sit back and think that if they don't hold it, then you're going to be protected. Now, there are some aspects of the decision that raise questions. The first question that arises is the court assumes in its decision that somehow IEPs are held in May for the next year, and that's always the way it happens. As many of you know, that's not necessarily the way things happen. We might have a February 2022 IEP that goes until the following February. So that if you have not asked for another IEP for the 22-23 school year, are you going to be barred under Capistrano? I assert that you will not, because you had an annual IEP as to which you submitted a disagreement, and that disagreement was effectively good through February of 2023. I suspect there is going to be a great deal of litigation about that aspect of this. School districts have turned a blind eye to the fact that there are many IEPs out there which do not have an end date at the end of a particular school year, but rather cover two parts of the school year. When they take the position, well, if you didn't ask for another one, then you don't have a right to have one. So I think one of the things that we need to be very careful about when we look at this is what is the period of time that is being covered by this, by the IEP that's in question. Secondly, there is some question in this decision. There's a whole area of the law that appears never to have been briefed and never to have been addressed, and that's child find. Child find continues to exist. I think that there are cases in which families will be asserting that they were denied child find, in that the district did not in fact do what it was required to do by child find, and therefore this case is not applicable. So while I think there are issues and the case is not the end of special education for students who have been taken by their parents to private schools, that some districts seem to think it is, the reality is that the lesson from this case that everybody must now be aware of, if you want to have an IEP for your child, to plan for the upcoming school year, and your child is not currently enrolled in a public school setting, you must make a written request. It has to be in writing. It's not enough to say, I told the teacher or I told somebody on the phone. It must be in writing, and it must get to the appropriate people in the school district so that you can show that you made the request. As always, when working with public education agencies, you should make sure you have a copy of your request and that you can demonstrate that it actually was sent. It is the case that if you do not make that request, you have a high likelihood of not being able to get your rights under IDEA until such time as you have the IEP. Now, the question that has arisen most recently is, what if I did not know about the Capistrano case and I didn't ask for the IEP until August? Is that going to protect me? It will protect you from the period of time when they should have held the IEP. So let's assume you make the request on the first day of school, and let's assume it's a district whose first day of school is August 15th. You might expect that the district will give you an assessment plan. If they do that, you really need to return the assessment plan. I think one of the lessons from Capistrano that is very telling, and I think we all need to be paying attention to, is that absent very extreme circumstances, there's no basis for refusing to agree to an assessment. If you refuse to agree to an assessment, there's a high probability that will also be used against you and you will lose all your rights. So that in my example, if you ask on August 15th for it, the district's supposed to get you an assessment plan within 15 days. They will then take their full 60 days to do the assessment. So by that point, you're in October, and you're really talking about perhaps having relief as of November, instead of not having relief for the entire year. The reality is, whenever you do it, you must make sure you have asked for an IEP meeting. And it really needs to be done now and should become part of our liturgy, if you would, that yes, I did ask for, and I did it in writing. I did see a question come through, and I know I'm not supposed to answer when we go along, but I'm going to take this one. Is email sufficient? I've pondered that question a lot over the last 8 weeks, 10 weeks, because we've been asked it a lot. I think if you can show you had valid email addresses and that you on your system have the function such that if it is not delivered, it bounces back to you, it should, in my opinion, be able to be used. Better, however, is either hand delivery to the school or mail, registered mail, so you can show it was mailed. One of the questions that has come up is, to whom do you mail it? In the smaller districts, Mailing it to the Director of Special Education, which you should be able to identify on the website of the district, seems to make sense. In the larger districts, I believe taking it to what would have been your school of residence had you been attending public school makes sense. I also want to point out the following. If you have an IEP, even if you have disagreed with the prior IEP, you have a right to ask for a new one and to have it held within 30 days. So that in fact, if you've got one of these IEPs that crosses the years, it was done in February, but goes to the next February, I don't believe you're subjecting yourself to a whole new round of assessments in that case. I think you're simply asking for the 30-day IEP. But I do want you to know that this case exists, that it changes dramatically the way special education law has been practiced by plaintiffs' lawyers for 40 years in the state of California, and that you do need to know it exists and be aware of it.
Thank you, Valerie. It's going to be interesting also because we don't know how the Office of Administrative Hearings is going to interpret this law or this case yet, because there hasn't been any cases that have come down interpreting it yet. So let me go to the next slide.
Has David returned?
I don't know.
David, are you on?
Not yet. Okay, we'll
Okay.
come back to
No,
Dave.
I am on.
Oh, you're here?
I'm sorry, I can
Okay.
see you guys. I guess you can't see me.
We
Okay,
can't,
we're going to go back and then pick up the front part where David was going to start.
right. Just an update, David, on the legislation on AB 130 and the case that's pending.
Okay. So pandemic school closures began in spring of 2020, and for the legislative year of the beginning in July of 2020, the state allowed all schools in California to have programs through distance learning, and they were allowed to kind of have a wide latitude of how they delivered their programs based on the unique needs of their communities. It's different for rural communities, different size school districts, different programs within school districts. And so there was a lot of variety throughout the state in terms of, scrambling to put together and build appropriate distance learning programs that, some people had good experiences, many people had bad experiences, and everybody kind of suffered through the year. So that was the 2020-2021 school year. And so the previous rule that if schools wanted funding for student attendance, it was all of their school funding was based on the number of students in seats in school. And that had to be in person. There were some limited exceptions for students who had, home hospital instruction for health issues. And there was a very limited statutory exception for students who were doing independent study, which was a specific type of program described by statute that required a lot of independence and very little adult supervision. So students had to be, quite independent. It was only designed for students who were able to pass their classes with minimal adult support, and who were on the core general education curriculum. So that had existed. That independent study law had existed for a long time. And after the 2020-2021 school year, when every district in the state was allowed to have distance learning programs that they created, and there wasn't a lot of regulation by the state in how districts did that. They were allowed to have all creative solutions. For the 2021-2022 school year, the school year that's just ending, the state wanted to emphasize the importance of getting as many kids back in classrooms as possible. Because the general consensus is that if kids are able to be educated in person, it's going to be more beneficial to them. And so beginning in July, so a lot of people at the end of last school year were under the impression that they would be able to continue on some kind of distance learning program. And a lot of people had IEPs to that effect, where they told the team, I think for health reasons or educational reasons, my child needs to continue this type of distance learning program. In the middle of summer, the law changed. And because the state legislature wanted to get kids back into schools physically, and they wanted that to be, they wanted it to be, to strongly discourage students from continuing on a distance learning model and districts from providing that model, they made a law called AB 130, which was the funding law for the state educational programs for K through 12. And that law said that everybody, if districts wanted to get funded for student attendance, they had to have the students back in person. However, they made an exception for only one exception, but it was accessible to anyone supposedly, which was parents of their own election. They didn't have to prove anything. If parents chose, they could have their child enroll in an independent study program. And that happened in the middle of summer without a lot of warning to the school districts. So for general education students, it was a bit of a scramble because districts had to either start independent study programs if they didn't have fully fleshed out independent study programs. Other places had to massively expand them. Like LUSD had a relatively large program, but it went from, I think, 1,500 students to 14,000 within a matter of weeks. So for general education students who were able to access their education independently through the previously set up independent study framework, that law wasn't a big deal. But by forcing everyone to use only that one method of accessing their education, if they needed a distance programming, what it did is it put a ton of pressure on students with disabilities, and a lot of you experienced that. And so IEP teams had to meet as part of the laws. IEP teams had to meet and make the change. So that caused a large amount of delay. And IEP teams also felt empowered based on early interpretations of the law to just say no to people. So the core reasons that they denied independent study, which made sense based on the law was written, the way the law was written, was they would say either you're not an independent learner, you require a lot of adult supports and services, so it would be inappropriate for you to have access to that program, or you're on the alternate curriculum because the pre-existing independent study legislation pretty clearly stated that students on the alternate curriculum could not access it. And also students who had been in non-public school programs, even if the non-public school was prepared to continue offering a distance learning option, the law explicitly prohibited that. And so a lot of people got rejected. And for many students with disabilities who had heightened health concerns and would have had much, needed to be a lot more careful with respect to the pandemic, they simply couldn't access an in-person program. And since the only option was a program that they'd been denied, there were lots of kids out of school. So our firm worked with Disability Rights California, and then we were joined, we filed the case, then we were joined with by DREDF, Disability Rights Education and Defense Fund. Eventually the ARC of California came on also. And so a large coalition of groups, we filed the case in the Northern District of California seeking to enjoin the state from applying this law in the way that it had been applied, and trying to force them to allow all students, including students with significant support needs due to disabilities, to access independent a distance learning program, whether it be independent study or some other version. That worked. Kind of surprisingly, we won. Ultimately, we won a statewide preliminary injunction, which ruled that that the law had been discriminatory, and that the way it had been applied had discriminated quite broadly against students with significant support needs due to their disabilities. And it ordered the state and the local educational agencies below the state level to allow students to access the program, and also to allow students in non-public schools to access their program virtually if that's what was necessary. So that issued in the end of February. Almost immediately, the Ninth Circuit issued a stay because it's a very sweeping order. And so since that time, we've been in negotiations with the state about trying to provide greater protection so that the same discriminatory laws don't occur, and that people have the ability to access a distance learning program if their student needs it for their safety. And so what those negotiations have kind of shifted into is this law, as you can tell by the earlier description of, each year it seems to change what the educational funding law is saying. They're renewing, again, this AB 130, the law that caused all these problems, is ending at the end of June, and a new educational funding bill will be implemented. So that bill, although it doesn't, in its current, and they're still negotiating, there's still, the whole kind of process of legislation with lobbyists and all kinds of interest groups and stuff is still occurring in Sacramento. But it appears that much of the language that was specifically enjoined by the court has been removed. So they've deleted the section in the current draft that prohibited students who are on the alternate curriculum from accessing a distance learning program. They have sections have been proposed which explicitly allows students who are in non-public schools to receive their education through their non-public school. And it's very clear that the presumption in the law is very clear that the presumption for districts which are going to have independent study programs, the presumption is that students with disabilities will be allowed. Previously, it had been written in a negative way that the presumption was that they kind of had to prove that it would be appropriate for them. So students with significant support needs should be able to access their the independent study programs that exist. That legislation is not final, and we're not sure exactly what form it's going to take, but it seems like it shouldn't be as bad. But the one thing that we really learned, the one thing that was borne out by the success of the litigation, is that the IEP teams they can't stop at the idea of saying, well, do we think this is the most appropriate program? Do we think that this is safe? When they're evaluating whether a student can receive access to a district's distance learning program, whatever form it takes. They can't stop there, because for students who simply can't access an in-person program safely, they still have the obligation to take that second step and consider whether, under the Americans with Disabilities Act, the student is entitled to an accommodation that will allow a reasonable accommodation that will allow them to access the educational program that the district is offering. So they can't just say, yes, we've made an offer. If you show up, you'll have an appropriate education, even though you might be exposed to COVID and have horrible adverse health consequences. They can't be cavalier like that anymore. They can't say that. It's been pretty well established now that they have to consider the second step of providing accommodations individualized to the student and trying, and ensuring that they have access to an educational program. And I think the rigidity of the success of that lawsuit has kind of taken away the excuse that districts can act with rigidity and without, under IDEA, it's individualization, but, they can't just say, we've offered a program that would meet your needs. Were you able to access it? They actually have to consider whether you can access it and whether reasonable accommodations are necessary to allow you to take advantage of the educational program. And so there will be something in the fall, but the legislation is not complete yet. There'll be some kind of distance learning option. And I don't know exactly how that's going to look. Presumably there will be another frantic scramble in the middle of summer for districts to try and make sure they're complying with the law, but at least there's more of a heads up this year that this is coming down the pike. So it shouldn't be as bad as last year. And some districts like LAUSD appear to be developing pretty robust ongoing independent study options or distance learning options that students can access. So that is roughly where I am. I don't know.
Thank you, David. We appreciate that, that update. Okay, so I'm going to move to, if I can get this, hold on. I have to change back to regression. I want to talk about that because a lot of our children did regress during the pandemic and weren't able to access an appropriate education during COVID and during distance learning. And so when there's been a denial of a free appropriate public education, the remedy is compensatory educational services. And then after the pandemic, the districts were saying, well, it's not our fault that children regressed, it's the fault of the pandemic. So instead of looking at compensatory or calling it compensatory educational services, they were calling it recoupment. Sorry. And it doesn't matter what they called it. The fact of the matter is that students did regress. And so LA Unified developed this plan to address learning loss in all students. And it didn't really go as planned. So, and I want to go back to this slide in terms of measuring regression, because I want to talk about what happened. The United States Department of Education, Office of Civil Rights, did an investigation of LA Unified based on complaints that they were not providing appropriate compensatory services to children who regressed during the pandemic. So OCR, the Office of Civil Rights, opened the complaint or their investigation in January of 2021. Okay, so more than a year ago. And they just came out with, they came out with their findings and they came out with an agreement with LA Unified. So the Office of Civil Rights found that LA Unified limited the services provided to students with disabilities based on considerations that had nothing to do with their educational needs. They did not conduct evaluations of students with disabilities prior to making significant changes to their placements, and did not ensure that the placement decisions were made by a group of persons knowledgeable about the student's needs. Now, this whole thing is also available on our website, and it makes for some interesting reading. There was the investigation, and then on April 27th, Alberto Carvalho entered into a resolution agreement with the Office of Civil Rights. So to talk about a little bit about compensatory education and what this resolution agreement provides. It says that compensatory services are required to remedy any educational or other deficits that result from the student with a disability not receiving the evaluations or services to which they are entitled. So that basically just defines compensatory services and doesn't really talk about recoupment. The agreement requires LA Unified to develop a plan for providing compensatory educational services for students who were impacted. And that's in addition to whatever recoupment or compensatory procedures are already in effect. I've seen a lot of IEPs come across my desk recently that have inserted, LA Unified particularly, but have inserted a box that says, is the child or was the child affected by the pandemic? Did the child regress? Is the child entitled to recoupment? And a lot of boxes that are just checked no. And clients have said to us, we never even discussed that at the time of the IEP meeting. So this is something that will really focus on compensatory education. So the agreement also requires the district to designate a plan administrator to develop this compensatory educational program and determine the criteria that's being used to determine whether there's been a denial of free appropriate public education. The determinations are to be made by an IEP team or during a 504 meeting as to whether or not the student was denied a FAPE during the pandemic. And by considering the student's IEP or 504 plan, and then also considering the frequency and duration of missed instruction and related services, whether what was provided was appropriate to meet the student's needs, the student's present levels of performance, previous progress, results of updated evaluations, and whether or not evaluations were delayed. Okay, so this agreement also says that parents have the right to copies of all documents and information recorded by the district regarding instruction and services that were provided during the pandemic, including service logs. And parents have the right to dispute the determination made by the IEP at 504 or 514 as to what is appropriate compensatory education for their child. And that will be disputed using the same dispute resolution procedures available under the law. And Sophia is going to talk about due process and other dispute resolution in a few minutes. And then the requirement is that the IEP team or the 504 team must document the discussion of comp ed, whether or not there was a determination that was made that the student requires it, and if so, the details of how it's going to be delivered, the amounts of the service, the time frame, et cetera. The interesting thing is too, is that the district is being required to track and report all determinations to the Office of Civil Rights on a quarterly basis. So let me go back a second to talk about measuring regression. So the LA Unified is supposed to be coming up with a criteria to determine how they're going to measure regression. And there's plenty of families on this webinar that aren't in LA Unified. So I want to talk about how we measure regression, because I think it's very important that if your child did regress during the pandemic, that you do ask for compensatory educational services. However, you have to be able to show the regression, and sometimes that can be difficult. So whatever documentation you have, and if you participated in any of our previous webinars, we said document, take videos, document some more, take more videos. Anything you have while your child was at home with you trying to access their educational program through distance learning, and showing that your child was not able to access it would be very telling in terms of determining the regression that was that your child had. So previous assessment results, to look at that compared with new assessment results. But one of the problems we're seeing also is that assessments have been delayed, like I said earlier. And so there's been a lot of time in between the previous assessments and the new assessments. And so I think we're going to have to look carefully at the previous assessments and then what new assessments have to say. Progress on or lack thereof on goals and objectives is important to look at. Documenting what services supports were in the child's IEP, what was provided during the shutdown or during distance learning, and what wasn't provided during distance learning, and any documentation regarding the child's ability to access those services. And the services that could reasonably be offered but were not during the shutdown definitely result in a claim for compensatory education. keeping in mind that there's this 2-year statute of limitations from the time you became aware of the facts giving rise to a claim for compensatory education. And so we've passed that as of March, I believe March 16th was when schools shut down. And there might be some, some time frame closer. But if you do think that your child has regressed and that you have a claim for compensatory education, you should definitely gather whatever evidence you have, and you should either file a claim on your own or hire an attorney to file that claim for you. We would suggest that you at least get a consultation with one of our attorneys so that you know where you're going and how to get there. That being said, one of the questions that keeps coming up regularly is the question of bullying and kids with special needs being bullied and how the districts are dealing with it. And I'm going to let Jody talk about that.
So we're getting an increase in calls about bullying issues, and I'm hearing it's rumored because kids were cooped up for so long on distance learning that now they're having difficulty reacclimating back into social settings. Whatever the case may be, does seem to be an increase. So I just want to touch base really quickly on maybe just a little overview on some things you can do. So bullying is defined as an aggression used within a relationship where the aggressor has more real or perceived power than the target. And that aggression is repeated or has the potential to be repeated. And there's a variety of types of bullying that can occur. So it can be physical, it can be psychological, it can be social. It all focuses on a real or perceived imbalance of power. And so that can include overt physical behavior where you're hitting somebody, the bully is hitting someone or physically attacking another. It can be emotional and social behavior where you're threatening. It can be cyberbullying. And the California Education Code actually sets forth a variety of instances in which a bully can be suspended. And that's based on essentially what they deem a reasonable pupil's perception to be of various activities. And a student with exceptional needs, a student with an IEP, is included in that definition of reasonable pupil. So a bully could be suspended, or bullying acts could consist of a physical or verbal act, including communications made in writing that are reasonably predicted to have the effect of or do have an effect on one of the following. So it's placing a reasonable pupil in fear of harm to his person or property, causing that pupil to experience a substantially detrimental effect on his mental health, interfering with the pupil's ability to participate in school activities, interfering with the pupil's ability to perform academically. And it can include electronic acts, and that can occur either on campus or off campus. It does not have to occur on the school site for it to be deemed bullying at school. And that can include electronic devices, wireless telephones, computers, pagers, and it can be a message, a text, a sound bite, a video, an image. It can be posting on a social network site. It can be creating a burn page or creating an imposter's profile. And it can include cybersexual bullying. So the Ed Code is pretty specific as to the variety of scenarios where bullying, that's describing various instances of bullying. And so then we need to consider whether, if there's a bullying situation involving a student with an IEP, does that constitute a denial of a free appropriate public education? And the answer is it's not clear. We heard earlier about Andrew F. case, and that says that the district must provide an IEP reasonably calculated to enable the child to make progress appropriate in light of his or her circumstances. And so the key here in looking at whether or not bullying constitutes a denial of FAPE is looking to the student's progress. Is the bullying preventing that child with an IEP from making progress. And if so, it can constitute a denial of FAPE. If you're speculating as to whether or not the child will make progress based on the bullying, that's likely not going to be a denial of FAPE. It could be a denial of FAPE also if the district fails to consider the effects of the bullying on the student. And so that brings us to the school's obligations. So when there's a bullying scenario, a school cannot just automatically make changes to the victim's program if he has an IEP. They can't make a change in placement, they can't change services. That could be in violation of not getting parental consent and changing the child's program. So they're supposed to convene an IEP meeting and review the student's needs at the meeting and determine whether there needs to be an adjustment of placement or services to address the bullying. They also have to, again, consider the effects of the bullying on the student. And they should also be looking for a child find situation, which Valerie talked about earlier. But in this case, looking to see whether maybe there's a situation or a condition that hasn't yet been identified that the student who's being bullied might be suffering from. For example, maybe he's got deficits in social skills and that hasn't been addressed in his IEP, but that's making him the target for bullying. So they need to look at whether there's any conditions that are existing that aren't being addressed and need to be addressed. And that actually goes the same for the bully. It creates, if your child doesn't have an IEP, but maybe in need of an IEP, it creates a child find situation for the district to look at whether there's some other situation that would identify the bully as being in need of special education services. If the child who's being bullied is afraid to go to school because of the bullying situation, the district or the school is obligated to figure out a plan and work with you to get the student to be able to return to school. And then the other thing I'm seeing that I just wanted to bring up is these behavior contracts. So lately, for some reason, behavior contracts are being given to the kid who's being bullied. And I just want you to be aware of them and watch out for them. They'll have you sign them. It has the child agree to all of these conditions, limited places on the play yard, reporting to adults. It really makes it seem like the victim is the bully. So just be aware of those. They're not required. They can be changed. It should be a collaborative plan. So just be aware of that. Other things you can do if your child's being bullied, you can send a letter to the school called the Gebser letter, which is essentially putting them on notice that your child's being bullied on the basis of their disabilities. You can file a uniform complaint, which every district is required to have. They're required to have uniform complaint procedures, and that's to allow for prompt and equitable resolutions of discrimination, harassment, intimidation, and bullying complaints. You have to file those complaints within 6 months of the incidents. The district then will investigate and has 60 days to investigate and issue its findings. And then you have 15 days to appeal that decision. And districts should have on their website that form available to you. And then if there is a denial of FAPE related to the bullying, you can also file for due process, which I believe Sophia is going to get to in a minute, to seek reimbursement for services that you may have had to provide to address the bullying, or to seek compensatory services, maybe some counseling or something to address the effects of the bullying on your child. But again, you have to show a lack of progress related to the bullying that was endured. So it's kind of just a quick overview there for you.
Thank you, Jody. One of the things that we've been getting calls about is when a child's been bullied, the parents just refuse to send the child back to school. And then I've had a couple of calls where children have been out of school for a very lengthy period of time and nothing is being done. The child's not getting any education. So I would caution parents not to just pull your child out of school, but to call for an IEP meeting if your child has an IEP, or call for any meeting if your child doesn't have an IEP to try to resolve the situation and make sure that it is resolved so that your child is being safe. And sometimes it's going to require, sometimes you'll have a disagreement, and sometimes it's going to require you to go to the next level, which involves either some informal dispute resolution or due process. And Sophia is going to talk about that.
I'm unmuted now. Hi, everyone. Dina, can you push this, go to the next slide? I don't know how to do that. If someone tells me, I'll do it. Next slide, but
I've got it.
great, thanks. So what happens when you disagree? And I've been seeing some chatter, I'm not supposed to look, about UCP complaints not being helpful, etc. And, you know, just piggybacking on what Jody said in terms of options, you know, in the situation of bullying or harm, the Gebser letter preserves your rights. But what happens if you have a disagreement on what is the most common experience? You disagree with the assessments, and then you disagree with what was offered at the IEP. And just one little note about that, you can revoke your consent to an IEP. Sometimes, you know, a new client comes and they say, oh, I didn't know I could disagree. And the first order of business is to revoke the consent to whatever the last IEP was. And you can do that. It has to be done in writing. And again, like everyone has said, you deliver that information in a way that you can then later prove you sent it. You can request an IEP. Districts have 30 calendar days to hold an IEP. I will tell you that you need to know the last day of instruction for your district, and LAUSD, because I had to look it up today, it happens to be June 11th. So you count back from those 30 calendar days. You have available to you various forms of dispute resolution. There's alternative dispute resolution, informal dispute resolution, and there's due process. And we're going to talk about what due process is. We're going to have a little bit of a civics lesson. I'm ready for the next slide. Due process, and here's your very quick civics lessons. It comes from the Fifth Amendment from the Bill of Rights to the Constitution. And that it then applied to all the states through the 14th Amendment. I know that's, and it's called due process because you're not allowed to be deprived of your life, liberty, or property without due process of law. And your child's right to education is an interest that is protected. And so that's why you're allowed to have this due process of law, some sort of fairness in a procedure. So they have to, all states have to operate within the law, and they have to provide fair procedures. For a lot of you, this is either you have no interest or it's something you already know. But your child's education is your important interest. So what it actually, we call it due process, and it's a requirement under the IDEA that it ensures children who are eligible for special education to receive a free and appropriate public education. So you have rights on behalf of your child under this law. Those are the rights being protected, as I said before. And you have an interest in your child getting not any education, but an appropriate education. So if you, at every IEP meeting, you get those procedural safeguards, or should, and if you don't, you need to let your lawyer know, or your advocate. You should read them at least once. Something that parents don't always realize, and Valerie brought it up when she was discussing Capo, the Capistrano case, sorry about that, is that districts can file to defend their IEP offer when there's a dispute. They also can file to defend their evaluations when you disagree with their evaluation and request a private assessment. And some of you are aware that with private assessments, districts have an obligation to either fund it or file against you to defend theirs within a reasonable amount of time. Reasonable is around 3 months, give or take. So, so it's important to know that a district can also file against you when you disagree. They tend not to, except for on the evaluations, but sometimes they do. So here are the different pathways with due process. And due process is a formal complaint is filed, and there's a couple stops along the way to resolution. And we are going to talk about ADR and IDR as well. But assuming that you filed for due process and or you had an attorney do so, districts, there's a resolution session. And the only way not to attend the resolution session is districts have the right to waive it. You can always ask. I mean, the intention was to have an informal meeting, and they're not confidential, although you can ask for confidential, you can agree to make it confidential. If you bring an attorney, the district can bring an attorney. But there aren't fees under the statute for resolution sessions in the same way that there is for mediation and hearing, with caveats. There are alternatives to bringing your attorney or advocate. You can prepare for it and stick to the script of your complaint that was filed. A lot of parents ask us about mediation. Is it even worthwhile? And I think it's really important to remember that mediation is voluntary. Either party can decide not to participate and march straight to hearing. But it's worth considering the fact that the majority of cases settle at mediation, and it's worthwhile. There are some exceptions to it being worthwhile, but you get to at least hear one another's perspective, and it's confidential. So, you know, we do suggest that you go to mediation unless your case falls into one of those exceptions. So, also, it's because you get to craft your remedy, what you're looking for. If you leave it in the hands of a judge, you run a lot of risks. California is notorious, and I use that word intentionally, for stingy relief through the hearing process. And it's risky. Plus, you have to provide expert witnesses that who get reimbursed for their time, and it's not reimbursable to parents. We call it a hearing, by the way. I should have started. It's a trial. Both sides present evidence. The only difference is we don't have discovery in this administrative law forum. What evidence is witnesses and documents, about documents such as the IEPs, evaluations, maybe some logs, service logs, etc. And as I said, it's the ALJ, the administrative law judge, who decides, not the two parties. And that's what it is. You just can't predict what a judge will decide. There is expedited due process when a student is expelled. It's faster timelines. It's for discipline issues usually, and a quick resolution is needed. And again, the Office of Administrative Hearings decides. I don't know if that's a quick enough overview for you of where it came from, what it is, but it is what most of you are familiar with. A complaint is filed. You go either to resolution and then mediation, and then possibly to trial or hearing. A lot of funding came down the pike in the 2020 Budget Act from the state legislature, 8.6 million, in addition to the almost 2 million in ADR grants. The upside of ADR, which is alternative dispute resolution or informal dispute resolution, is that they're faster. They can't be used to delay your right to due process, but they're faster. And for some parents who are really worried about maintaining their relationship with the district, it's seen as a friendlier forum, if you will. That said, and it's definitely, this happens all the time. We get presented with an intake with an ADR or IDR agreement, and a parent isn't aware that what they've done is waive their rights from that date, typically back, sometimes forward, because there's always waivers, because the entire motivation for a district to enter into any agreement, whether it's through the ADR process, IDR process, resolution session, or mediation, is to not spend the money, time, and effort in going to a formal due process hearing. So that's the motivation. And it involves compromise, but it settles things from typically the day that everyone signs. Again, sometimes it reaches into the future, back. That's the motivation to settle, is that they don't have to think about what happened, what they may have done wrong. It's all done. So the waivers are something that you have to really be conscious of if you end up going down, choosing to go through ADR or IDR. And, we're protective of our clients, advocates and attorneys are. And so we get nervous, and I've seen a lot of people come in with an agreement. And there's not a lot we can do. We can only then look forward to what's not working now. So
And could I just interrupt for a minute on this issue of what's called ADR? It's called different things in different places. ADR stands for Alternative Dispute Resolution, but in other places it's called Independent Dispute Resolution, Informal Dispute Resolution. Almost every district in Los Angeles County received a bucket of money from the California Department of Education to operate an informal dispute resolution process to address the concerns they saw coming out of the pandemic. There are folks who lobbied, some folks I think who are participants here today, who lobbied heavily to make sure that money wasn't spent on attorneys. So it says that districts cannot use the money to pay for attorneys. Unfortunately, what it did not say is they had to use it for direct services. So for example, Los Angeles Unified got $10 million of that money. If you look at Los Angeles Unified's plan, it is simply to hire more people to go talk to families to have, in my cynical view, have them give away their rights. What ought to be done in those cases and what people ought to be asking for are actual direct services to students. That money should not be being spent, in my opinion, to hire people to go to people and say, here, just agree that you can get, what is the latest one I saw today? We'll give you 840 minutes of speech, however we want to and whenever we decided to make up for what you've lost. That is not okay under the law. And what that person is who's coming to you with that is someone who's being paid out of this $10 million to get you to sign off on that and agree to it. So there's a lot of money there that they've used to hire people to come out and talk to you about giving up some of the recoupment and reimbursements and the remediation rights that you have. Just remember that you should be asking for direct services and be very, very cautious of alternative dispute resolution. I am not saying it's a bad thing. I'm not saying, you know, throw it out, don't ever do it. What I'm telling you is be very, very cautious. Sorry, Sophia.
No worries, Valerie. You always add amazing perspective. So thank you. I agree with Valerie. I think we all do that. You know, we're protective of parent rights. There are other complaints that can be filed, and this is not an exhaustive list. The ones that come to mind and annoy districts are the compliance complaints. It's a pretty straightforward process, and you know, parents can file compliance complaints. You know, they investigate CDE, the California Department of Education investigates. You know, it's a coin toss about how they'll come out and or how useful they are. So again, you proceed with caution on that one. There's also OCR complaints. I don't know, Valerie, I'd like you to weigh in on those two types of complaints.
If there's folks on here who have been with me during the 40-year slog, you'll know that I was not for many, many years a fan of compliance complaints, and that similarly, I've not really pushed very hard for civil rights complaints. I believe in 2022, all bets are off. I believe that with regard to school districts, and particularly with regard to the Los Angeles Unified School District, every time there is the smell of a complaint, it should be filed. Los Angeles Unified School District, Long Beach Unified, some of the larger districts have gotten away for a very long time with hiding behind the fact that they're large. And at this point in time, if you, for example, have something that you were promised in your IEP and it wasn't offered, get it in there. Get a compliance complaint filed. If you have the ability to show there was discrimination based upon your child's disability, seriously consider filing an Office of Civil Rights complaint. We should not be backing off from those at this point in time, in this point in history. In my opinion, good educators have forgotten our kids. Good educators have forgotten what was behind what was called at the time 94-142. Public Law 94-142 is where this all started. It was the initial citation to the federal legislation that started it all. That was a moment of great hope a moment of great promise, a moment when we believed that not only could the schoolhouse doors be open for children, but they could actually get benefit from going through those doors. The educators who believed that, who believed in special ed and all that it had to come with it, have retired or died. And the people that have come after them seem to think that because nobody's being cured, it doesn't matter and we can go back to warehousing children. I get up every morning in fear that I am going to hear about one more classroom that is a warehouse. One more situation where we have once again dumped a whole lot of kids together in one setting who don't have any common education needs. We need to go back to the picket lines, if you would. We need to go back and start over, reminding people that there is a benefit to education and we ought to use every mechanism we have to do it, however we use it. And that includes compliance complaints and Office of Civil Rights complaints. And that's my soapbox for today. I apologize and I'll step down.
Well, preach it, Valerie. Preach it. The links to the compliance complaint and the OCR complaints are on that slide, and they're worth, parents can do a lot more than what you think you can do. So there you heard it. That's the last bit on complaints. And unfortunately, you're going to hear me a little bit longer. And this may become a separate little webinar. It's about settlement agreements. And the reason why it's up here is that some of you ask questions about the settlement agreement. We go through it, we explain it. And 2 months later, we'll sometimes hear, oh, I don't remember that. And it really, like, we went over it and we reviewed it and we checked for your understanding. And I know I sound defensive, and that's why the need to explain settlement agreements comes up, because they're so important. It's a contract, essentially. Like, you're buying a car. Well, this is a contract between you and the district about your child and what your child's going to get. So it is incredibly boring to read the fine print. Everyone knows that. But there's not so much of that like there is in other contracts, and you really do need to understand it. And you have to ask questions and you have to get answers before you sign that contract, because it's binding. I'm going to call it a settlement agreement from now on. It's a roadmap. So things that you can do once you have a settlement agreement, and I know I talk about advanced preparation, but that has to do with reimbursement, and that doesn't apply to everyone, is some of what you can do is take a highlighter, get that settlement agreement, and highlight all the dates. Highlight the paragraph with the services. And there's dates attached. Usually an IEP will take place to review evaluations, whether they're private or done by the district. And you want to know those dates. You want to calendar those dates, because just like you have to comply with the settlement agreement to get the benefit, they have to comply, they being the district, with what they agreed to. Remember what Valerie just said about compliance complaints. So there's also other remedies for when they don't fulfill the settlement agreement like they're supposed to. So it's really important. It's really important that you understand the settlement agreement. Take notes, ask questions, get your questions answered. and use it as a roadmap, keep it printed and well, I'm old school, a print of it, but keep an electronic record of it if that's how you roll. And refer back to it. So that's what I'm going to say about it. They're really important. Now, for parents who are asking for reimbursement, there's a lot that you can do to prepare in advance. If you're asking for tuition, you're going to need attendance records, because part of settlement, they always talk about up to X amount of absences per semester or school year. So you need to have that information, the school name. Look at the private school calendar or a non-public school like Frostig, or any of the non-public schools. Know the start date and the finish date, because whatever your district is, they have their own calendar, and you have to make sure that you're going to be reimbursed for the entire amount, or at least know the start date and the finish date. So you want to calculate your mileage from home to school and back. You can do that on Google or MapQuest. If you have service providers that you have been paying and are seeking reimbursement, know their name, the proper spelling of their name, their hourly rate, and the frequency of the service that was provided, 1 time a week, 2 times a week, and the start and end date of the service. It's useful information to get in advance. We're going to quickly look at tools for settlement agreement, because I get this a lot. And that is, I don't have a scanner, and there are a lot of ways to deal with no scanner. No scanner, no problem. There's free scanner apps. And there are, if you don't have a printer, you can go to your local public library, and they have printers that you can use. I put in the website for that. If you have a teenager who is tech savvy in your community, go to them and have a highlighter and a red pen to circle your questions and your issues. Those are the basic tools. So very quickly, what you're looking for is the same thing that we talked about before in terms of waivers. They look back, meaning if it says through the date of full execution, or some, not all of them, and not that many, look forward and reach into the future, and the language would be something like settles all claims through some future date, the end of the school year. Highlight, as I said before, the terms and or the date, and write down on a separate little piece of paper what you agreed to, so you have it in your head, and write down what the district agreed to. Reimbursement, I'm speeding up because I see that there are a lot of questions. Reimbursement is a term of the agreement, and to get that, you need reimbursement forms, and every district does it differently. During the mediation, ask your attorney. We already went over what you need for tuition reimbursement, etc. It's important to keep in mind in advance that at some point you're going to have to prove your expenses, and you have documentation of your payment. It might look like redacted bank statements, canceled checks, to the degree people still use checks, redacted credit card statements, receipts. If there's third-party tuition entity, get the name of it and at least take screenshots of when you make that payment or when it's taken out of your bank account through automatic payment. Probably the most important thing that if you take away nothing else about reimbursement, you have to know the time frame for submission. The use by date, because if you don't submit by the use by date, you lose the reimbursement. That's why we're talking about thinking in advance of mediation. If you already know, look, I'm providing these services, at some point I'm going to seek reimbursement, start getting your ducks in a row now. It's important to note in a settlement agreement, if it says business days versus calendar days. Calendar days is just a regular calendar. There's a link to the time and date calculator. And that's kind of it on that. Over to you, Dina.
Thank you, Sophia. We really appreciate all that information. And now I'm going to introduce you all to Sheng Wei, our newest attorney, and she's going to talk a little bit about interpretation and translation. If I can get to that slide. There we go.
Okay. Hi, everyone. My name is Chong Yue. And you can probably tell from my name, I did not came from here. I was born and grew up in China, so my native language is actually not English. It's Mandarin Chinese. And while I'm new to Vanaman German, I worked at Learning Rights for 4 years, where I did work with many Chinese-speaking clients who did not know English at all. And through the whole process, I could tell how stressful and frustrating it could be for parents whose native language is not English to participate in this process. So that's why I want to talk a little bit about the laws regarding the interpretation and translation in the IEP process. So if you're a parent who is not proficient in English language, under the IDEA and the California law, there are certain documents that must be translated into your native language. So here is a list of a few examples of documents that you have seen most frequently, but it is not an exclusive list. So the first type of documents that you see most frequently is the procedural safeguards. They are typically provided to you prior to the IEP or at the beginning of the IEP meeting. And I think the district is pretty good at providing this in your native language because they just do one-time translation and it can give you to all of you who speak the same language. The second category is IEP documents. So under the law, you are entitled to a free copy of the IEP translated in your native language. However, it must be based upon your own request, which means you have to make the request before the district will provide you the translated IEP. In terms of the timeline, so there is no timeline as to when the district must translate the IEP and provide it to you. So the law says it must be timely. However, it is unclear what timely means. And the Office of Civil Rights has found that the district providing a translated copy 8 months after the IEP meeting is not timely. So there is some law and past records we can find to help determine what is not timely, but there is no straight answer. So if you think the district takes too long, it takes over a year, definitely you can take some actions on that, and I will address that later. And the suggestion for, ensure a more timely translation is set a specific date when you make this request. So for instance, after the IEP, you want the district to translate the IEP document into your native language. When you make that request, please also discuss with the IEP team when you can expect it. Try to set a date and make it in writing. And then after the IEP, the third category is information relevant to an activity for which a district is seeking a parent consent. For instance, if the district is providing you with an assessment plan, it is asking for your consent to do an assessment. This must be provided in your native language. And also IEP meeting notice. This is to seek your consent to participate in an IEP meeting. It must be provided into your native language. And also something that is not listed here and you may see frequently is prior written notices. They are notices that district provide to you to propose some change to your child's program. They may say, hey, we want to move your child to a different program, or they want to initiate some evaluation, or when you request an evaluation, they want to refuse your request. They have to do this through a prior written notice. And this prior written notice has to be translated into your own language. Because as we mentioned, the IEP translation can take a long time. It can take a few months. That's why interpretation at the IEP meeting is really important. So under the law, the district should take any action necessary to ensure that you understand the proceeding at the meeting, including arrange for an interpreter for you when your native language is not English. So it is clear that when you request an interpreter, they have to provide one, but it is unclear whether it has to be a certified interpreter. So the law does not say anything about that. But what we know for sure is the interpretation has to be good enough for you to have meaningful access to the meeting, which means that you can understand what is going on, and your information, what you want to tell the team, is being delivered accurately to the IEP team. So if you feel that when you are at the meeting, your interpreter is only translating 1 or 2 sentences while the other team members speak for like 10 minutes, definitely that interpretation is not good. And if there are some terminologies, especially we know in special education, there are many terminologies that can be hard to understand even in English. If you feel that the interpreters are not helping you to understand those terminologies, this may prevent you from meaningfully participating in this whole meeting. So interpretation is very important because, as we mentioned, the IEP document itself takes time. And the district, when they finish an assessment report, they're typically in English as well. So by participating in the IEP meeting, it's a very important opportunity for you to really understand what the IEP team is offering your child and what the assessment has said about your child. So here are a few suggestions to help you ensure a very effective interpretation. The first is to always ask people to take frequent pauses when they speak. Maybe I'm not doing a good job here. I should take more pauses, but when you are at the IEP meeting, please ask whoever is speaking to take frequent pauses so that the interpreter has sufficient time to translate. And also, when you don't understand something, either it's a word, a sentence, some terminology, or even it's an IEP goal, when you don't understand it, ask questions. Always ask questions, because the IEP is about you as a parent to know what your child's program is and what would benefit your child. So it's a really important opportunity for you to ask questions to make sure you understand what is being offered and make sure you understand your child's needs. So for you to help participate in the IEP, we would advise you to ask people to take frequent pauses, and when you don't understand something, always ask questions. And if you think the interpretation is really, really, really bad, even if you try to ask like a million of questions, you still don't understand what is going on, what you can do. So what you can do is to leave this IEP and ask the team to reschedule the IEP meeting with a different interpreter. You should tell the team immediately that you don't understand what it is going on and you cannot participate in this IEP without a better interpreter. So call the IEP meeting to a stop and ask the team to reschedule a new one. And the second thing you should do is to audio recording the meeting if you feel that an interpretation can be bad. Because by audio recording the meeting, you can later show and provide evidence if you want to file the complaint that the interpretation was just so bad that nobody could understand what the interpreter was talking about. And if you don't understand, if let's say there is an assessment report, and if you don't understand what was being reported, And even when during the IEP meeting, you don't want to, when the assessor was share his or her findings, you don't understand what was he saying. What you can do is you can ask a small meeting with the assessor and an interpreter, or maybe a special education case manager, to have a small meeting to go through the report. Because the assessment, because as we mentioned, the translation of IEP documents takes time. The assessment reports can even take longer, and you may not entitled to them. The law is very unclear on this, whether parents are entitled to translation of assessment reports. So if you don't understand assessment report, you can always schedule a separate meeting with the assessor and the interpreter to go over the report again and make sure you understand like the findings as to your child's needs and the recommendations. So if you make all those efforts, you leave the IEP, ask them to schedule a new one, you record IEP, and you schedule separate meetings with the assessors, and you still don't understand what is going on because the interpreter is just so bad. What you can do is you can file a complaint with the California Department of Education or OCR. You can alert that, for instance, if you requested the translation of IEP and it takes 2 years and you have not got a copy, you can file a compliance complaint with the California Department of Education to raise the issue that the translation is not timely. And if the interpreter is really bad at the IEP, you don't understand what happened at IEP, and the district never gave you a copy of translated IEP document, what you can do is you can file a discrimination claim with the Office of Civil Rights, because the district is discriminating you based on your nation of origin. We discussed the timeline for IEP translation. There is no clear timeline. And for assessment, the law is unclear on whether you're entitled to a copy of translated assessment. But as parents, when the assessment is being conducted, the assessor will have to obtain information from you. So in that process, you will have to work with an interpreter to make sure that you provide information to the assessor about your child's needs. So in that part, you also need to make sure that the interpreter is doing his or her job and is delivering the information to the district's assessor. And also the law requires that your child, if he or she does not speak English as the native language, the students need to be assessed in their own native language, which means that the assessor needs to work with an interpreter to assess your child. So those are pretty common issues that we see when we work with parents who do not speak English as their native language. And so when you have these issues, please try to, as parents, you should always know you have rights, and you are part of the IEP meeting, you are part of the decision maker. So you need to make efforts to make sure that the district ensure you have access and are meaningfully participating in the whole process.
Thank you. And Shengwe, one of
Yes,
these days I'm going to get it right. I'm trying really hard. Thank you. That was very informative. Okay, I'm going to stop sharing the screen. We've got lots of questions. We've got about 20 minutes, so I want to see if we can get to as many questions as we can. I'm going to ask my colleagues to jump in here if they see a question that they want to answer. And
one of the questions, Dina, that was asked and I did not write an answer to was a question on why did I say that I think parents are going to have to start agreeing to assessment plans. Let me tell you why I answered it the way I did and where I think we are. Those of you who have heard me in the past know that I believe in the 400% rule. I now believe it's an 800% rule. We need to be 800% better than the public school system. And if we are not, they are going to find a way to deny what we're after, what we're saying, the position we're taking. The assessment plans are essential element of due process of special education. You can get you cannot get special education if you don't allow the district to assess. And your remedy for a bad district assessment is to challenge it and request an independent assessment. But it's not a remedy to simply say, no, you cannot do it. Now, all of that said, 2 caveats. Remember, a district can only assess once a calendar year. One time a calendar year. So that if you come back and say, I think you didn't do this or that, they don't really have a right to say, oh, well, let's do a whole new assessment plan. They have a right to do it once a year. They can't continue to assess you over and over. Short of that, unless you can really show some really extreme circumstances, in order to remain in special education, if the district asks to assess your child, you are pretty much going to have to agree to it. And the law is pretty clear that you have only limited control over what instruments they're going to use and how they're going to do it. I have advised families most recently, if they're going to do their standard battery of assessments and you know your child, either because of the pandemic or for other reasons, is not going to tolerate it well, when you agree to it, one family I know signed an assessment plan recently that said, I gave you permission to assess, but please be aware that my child is extremely volatile at this period in time, and I am not responsible for any physical damage he may cause the assessors. So that in fact, you give notice if you know your child's having a particularly bad time or is going to react badly. But I think assessments do need to be agreed to. And I think under the Capistrano case, one of the reasons that family was not successful was they had denied the assessment.
If I could just also jump in here, one of my pet peeves is that there are no standardized assessments that are going to accurately assess a child who's nonverbal and not able to communicate in an efficient manner to answer questions. And that was my son's case when he was in school. And I have a lot of clients who are having the same problem. The assessors can't assess my child because they're not getting accurate information. Well, like Valerie is right, you need to let them do whatever they're going to do in the best way that they can by supplying them with as much information as you can regarding how to access information from your child. That said, once you get the assessment, if it's completely devoid of any appropriate recommendations or totally devoid of any appropriate information, then the next step is to get an independent assessment. And then the next step also is finding an independent assessor that can do an accurate assessment. So anyway, wanted to address that. Jody, there was one question here regarding bullying by a teacher, and a teacher threw a chair at a student, and what can the family do about that?
I think you're taking the same action with respect to putting the school on notice, potentially requesting a change in teacher. If there's proof and it's an assault, I suppose you could pursue some sort of civil claim or criminal claim, but you can file a complaint against the teacher. You can file a UCP complaint. I saw some questions about that and whether or not they're for students and whether or not they're effective, and whether or not the new restorative justice programs are doing anything. You know, the districts are investigating the UCP complaints themselves. Obviously, that leaves some room for them to be swaying everything in their favor. However, if you disagree with their findings and you have grounds for appeal, and there's certain rules for that, the appeal goes beyond the district. And I am aware of at least one case where a student was alleged to have been bullied. The district did its investigation per a complaint and found, of course, that the district did nothing wrong. The parents appealed to the state and the state is investigating. So I don't know what the outcome is going to be, but I don't think they're all for naught. I don't think the restorative justice pieces that I've seen are doing much other than sort of creating an adversarial situation at IEP meetings and dotting i's and crossing t's for the districts, but that's just what I've been seeing with it. But I think, you have to just explore every avenue as far as filing any complaint and putting the district on notice to the greatest extent you can when there's physical assaults being conducted on your kid.
And I do think, I used to say up until Monday at 11:50 p.m., I used to say, try and get along with the district as an initial step. I think now all bets are off. I think from the start go, you file every complaint you can find and you begin to make it public as to what's really going on. And whether we think they'll work or not, whether you're cynical about it and say it isn't going to get anywhere, the reality is the more that's done, the more we begin to break through the wall of secrecy that the pandemic has allowed public schools to raise. One of the terrible things about the pandemic is that parents can no longer go into the schools and see what's happening. And that, of course, makes it even more difficult. So if you got a complaint, file it, file it, file it.
Thank you, Valerie. Wow, there's a lot of a lot of questions and stuff. And Vindia, thank you. I know it's very difficult to assess nonverbal kids and kids that have lower IQs. I'm interested in finding ways to do that and get appropriate information. Vindia Fernandez is one of our assessors who does independent educational evaluations. And thank you for that. There was a question regarding if a parent signed a settlement agreement but felt coerced to sign it and did not receive adequate services, what is the recourse for the parent? Well, Sophia, you want to address that?
Sure. I mean, the recourse is, in my opinion, filing for due process, right? I mean, there's, it's connected to recoupment and regression, no matter what they call it, and what Dina talked about in terms of the findings against LAUSD. It's not just LAUSD. Kids regressed during COVID. Not everyone. I had a client just tell me that her child did really well during distance learning. But most of them did, and you're entitled to compensatory education, because there was another question, I may be answering the other question I saw, which is, are you entitled to comp ed? And the answer is yes. I mean, is your child? And the answer is yes, but it does go back to what Dina said in terms of regression, not just academically, but socially, emotionally, behaviorally, etc. So you're looking at a wide range there of what's available to be considered regression. I'm not sure that answered it, but that's my answer.
I think, Dina, that there's a couple of questions in Spanish that have shown up, and I'm wondering, Sonia, if you could take one of those perhaps and just share it with us in English, and we can then try and answer it. Does that work? Did I lose Sonia?
Oh, yes, we can hear you. Sonia, one of them was asking for a recommendation for an evaluation for an FBA, a functional behavior, an independent. Yeah. Well, yeah,
Yes.
the next one.
Why don't you do the next one also?
Okay.
Can we
In terms
answer
of
the
the functional behavioral assessment, would that be done in Spanish or, or in English? I don't know. I mean, if the child speaks English, they could do it in English. If somebody could answer that, I don't know what the
Here,
translation.
I
Okay.
think there's two parts to this question, I think. Is that I'm not sure what the purpose is of the functional behavioral assessment. That is, I know that's the term we use. I know that's what people call it. Mostly they're not very good. And mostly the districts are not paying enough to have a real behaviorist do a real assessment to look at behavior. So before I went searching for a quote unquote functional behavior analysis assessment, I would really take a look at what is it we're trying to show and what is it that we're trying to demonstrate and what do we need to get here. The second question that was asked is, if your child is only 3 right now, you would not be talking about a transitional kindergarten. What you would be talking about is a special education preschool, if that's what your child needs. So that there are some districts that will assess your 3-year-old and say your only need is for speech and language and we don't have to provide you any special education program. The Manhattan Beach Unified School District, for example, is fond of saying that and then having the family pay for their child to attend the preschool program that they are operating on a parent pay basis. That's not really the law. If your son or daughter has special education needs that require real programming during the day, they cannot limit the services to only speech and language, for example, or only OT. They have to provide you with a real preschool program. And that's what you ought to be looking at as you begin to look at what's available.
Thanks, Valerie. Here's an interesting question. If a public school agrees to provide an independent educational evaluation of parents choosing, would the parent ever be responsible to cover the cost? I.e., is it dependent on the testing outcome? And the answer to that is no, parents are not required to pay regardless of what the IEE finds. However, there are limits in terms, cost limits that are imposed by every special education local plan area as to various assessments for independent assessments, and the cost levels are not anywhere near where they need to be. So oftentimes we find ourselves having to negotiate for a higher amount of funding for an IEE. Anybody else have any information they want to share about that? Okay, let's see.
Well, there was another IEE related question that had to do with what if an IEE is funded and then they don't take the recommendations. And that's a very common scenario. The law does not say they have to consider the private evaluation, and that's essentially what it is, even when it's funded by the district. And usually that means you have to file for due process and say, you funded this, you ignored it. That's my 2 cents on that.
Well, and here's another question about this comes up all the time. What should parent do when school district files for due process after the parent requests an IEE? Should you go to mediation? Should you throw in the towel? It really depends on the situation, obviously, but sometimes parents will end up having to withdraw their request for an IEE if the district files for due process. And sometimes the parents want to go ahead with a hearing to prove that the district's assessment was not appropriate. But then you're dealing with experts having to prove that the district assessment was not appropriate, and it ends up costing the family money. Valerie, what's your take on that situation?
So I think it's hard.
Mm-hmm.
We're in the awful situation of having what we know to be a bad assessment, but to prove it's a bad assessment, we have to have somebody who's willing to testify it's a bad assessment.
Right.
Now, there are some cases in which the district used either inappropriate instruments because of age, inappropriate instruments because of some presentation in the child, other things. You can see back here on my shelf, if you could see what these books say back here, they say mental measurements yearbook on some of them, and they say tests in print on the other. So while some people think that I don't know very much in special education, those are books with which I am intimately familiar because they give you access into what are the instruments that are being used, what's the literature say about the instruments, and if you can prove that the instruments that were used were not sufficient, just simply from the literature that exists, then you have a good case and a chance to challenge the district's decision to not give you an IEE. The problem is that you won't always have that. And what you're going to have instead is a set of scores with which you disagree how they've been interpreted, but the scores themselves are accurate. That then becomes an issue, in my view, not so much as challenging and whether you need a new independent assessment, but challenging the outcome. Taking the district people to hearing, cross-examine them about how it is that they interpreted the scores in a particular way when the literature says they're not to be interpreted that way. Pushing it with regard to not that you need another assessment, but that this is not the way it should go. These IE cases can be won. Sophia won one during the height of the pandemic, but they take particular talent. They take particularly talented lawyers to do it, and they need to be thought through carefully. But they can be won, and I would not necessarily walk away with it without considering whether or not it's one that can be won. There are others that simply can't be won. It isn't any, makes no sense to put more bad money after good money or good money after bad money. So it's a case by case kind of a decision.
I'm sorry, did somebody else have a question?
Oh, I was just going to add a quick thing is that if you get an independent assessment, I think you want to take action if you agree with it relatively soon. What you don't want is that independent assessment to sit for a year and then say, but I have had this assessment, or if, because then it's a year old. So you want to like take the action necessary after you get the assessment when it's valid and present and right away. You don't want to
do not let those assessments go stale. And here's another place that you can file compliance complaints with CDE. The private assessor sends in the assessment to the district, and the district says, oh, and never gets around to doing it. Within 10 days, I have a new rule. New rule. What did the guy used to say on one of those tiers? New rule. New rule. This is the May 5th rule, Cinco de Mayo rule. Within 10 days of getting your private independent assessment, if the district hasn't scheduled an IEP, file a complaint with the CDE for non-compliance. New rule. And I'm going to start following myself for those independent assessors who are on the scale and know I haven't been following it. New rule, we're going to follow it.
Thank you, Valerie. Okay, it's just about 8 o'clock. I know we have a lot more questions. Let me just say that the pandemic has done some good things in the sense that we are meeting with families on a regular basis via Zoom or telephone consultation, and we are happy to have consultations with families regarding issues particular to your child. So please feel free to request a consultation with one of our attorneys. You can fill out the form on our website, and one of our assistants will call and schedule either a Zoom or a telephone meeting with you based on what your choice is. And it's a really great way to get a lot of questions answered. And at the moment, we are not charging for those. And so you get a free consultation with one of us.
The other thing, Dina, if I could just, before we close, I know we didn't answer all your questions and there were lots of questions and we apologize for that. I think that in the Zoom world, 2 hours is about all we can do. I know, Judy, you have a raft of questions about 504 and a lot of questions about 602, which we're obviously not going to get to tonight. I think, Janine, given the number of questions we got about 504, sooner rather than later, I think we need to set up a webinar on 504.
I agree.
And as soon as we get finished doing a little project that we've been given, we will work on getting that set up and do a separate 504 to answer a lot of the 504 questions that were raised here tonight.
Yes, that's great, Valerie. And I think I want to send out a survey to parents who, or all of our participants, regarding any subjects that you would like to have more detail about, and can we do a webinar on more, giving you more detailed information on a particular subject. So if we have enough interest other than 504, then we can certainly do more webinars. So thank you all.
And I do think that we might even be able to do, if there's an isolated topic that we get enough interest in, we might be able to do a 1 hour kind of a session that would cover one of those. So thank you, Dina, for putting this together, and thanks.
You're welcome. Thank you all for participating. Look for a survey from us. Feel free to reach out on our website and email us if there's information that you need more information on, or a subject that you need more information on. This webinar will be on our website in a few days, as will our PowerPoint. And so thank you all very much. Thank you to all of my esteemed colleagues for all of your information. And till we meet again. Thank you all.
Thank you, everybody.
Thank you, Sonia. Very much appreciate you. Bye.
Bye.